and welcome to this Breathe webinar. We're joined by our brilliant partners, Access to Human Resources today. We are covering a Q&A today, so we'll be answering all your questions about employment tribunals. You may have attended our last webinar with Dan and Tracey, where we were talking about how to avoid an employment tribunal. And backed by popular demand, there were lots of questions. So today we are here to answer your questions. What I'll do is now hand you over to an intro from both Dan and Tracey. So Dan, if you'd like to intro yourself.
Thank you, Amy. Yes, good morning, everybody. I'm in Amesbury, which is almost a stone's throw, or perhaps just a little bit more than a stone's throw from Stonehenge. And it is very sunny here as well this morning, so I hope it's nice where all you are. I started Access to Human Resources in order to support businesses who needed good, practical, friendly, expert and responsive HR help in order to A, stay out of trouble, and B, get rapid help when you get into trouble. So that's what we're about. I also work in employment tribunals and have done for over 20 years. So we have a lot of experience to be able to hopefully help answer your questions today that you've got around any tribunal matters that you've got going on, or indeed just in order to help you stay out of them as much as we possibly can.
Fab. Thank you, Dan. Pass over to Tracey.
Thank you, Amy. Morning, everybody. So I'm Tracey, and I've been working in HR for about 15 years. Been working with Dan since 2017, so we've worked together quite a long time now. We support a whole range of clients in our business. We've got people from all walks of life, all professions, all industries, people with all sorts of questions coming at us all day long, from the quite simple, what do I do if somebody's always late from work, right through to it's a little bit too late and it's now going to tribunal. So I hope that we'll be able to answer all of your questions today. We've only got 45 minutes, so we'll talk as fast as we possibly can. And obviously you want to get in touch with us afterwards via LinkedIn or ask Amy for our details. We'd be more than happy to talk to you. So I hope you enjoy this morning's session. Thank you.
Brilliant. Thank you so much, Tracey. As Tracey mentioned, this session will run for 45 minutes and we will make sure it's available on demand. So you can kind of listen back to the questions and answers anytime you like. I can see we've got a couple of people from across the UK today. We've got Glasgow and Edinburgh all the way down to Bristol. So thanks for sharing where you are. What we'll do first is I'd love to kick off with a poll. So we'd love to understand how confident you feel about your understanding of employment tribunals and how best to avoid them. So if you could please choose one of these answers, we can have a little look at how you're feeling about employment tribunals. And it does take a couple of minutes. So Tracey and Dan, what do you think could be what we're looking at today?
I think we will have a mixture of people, some who've experienced tribunals before, but obviously it's always nice to have a little bit of professional help. So I think we're going to have a mix between a B and a C going on here today. I don't know what you think, Dan.
Yeah, I think that's probably right. It would be a brave person to say they feel very confident and got it all covered, but you know, we may have some brave people in the audience.
Yeah.
We'll have to wait and see.
I'm not sure that I would tick A either, to be absolutely honest, because you never know how things are going to go, do you, in a tribunal? And it very much depends on who's there, who's listening, and yeah, exactly that. Yeah. So, yeah.
To some extent, I always liken it sometimes to a bit like when you take your driving test. You always think, well, you know, you never quite know what's going to happen on the day. You don't know what obstacles that you haven't foreseen that might crop up. You don't know what kind of mood the test is going to be in.
Doesn't it? Absolutely that. What's the tester like today? So it depends very much on what the tribunal panel are like on that day. So let's see what people have got to say. Somebody very confident. I think we've got someone from a panel in the audience today.
Yeah, maybe it's a tribunal judge.
It could be, couldn't it?
It is. It is. Good morning to
Share
you, my lad.
yourself. Yes, you can answer all of our questions for us.
Fab. Sort of as you predicted there, Tracy. So
Yeah.
B and C. So right, I think that's enough from me. What we'll do is we'll hand over now to Dan and Tracy for the Q&A. And we will have another poll about halfway through just to let you know. But let's go and get going with some of the questions we've got.
Okay, I've got a question here. How do I reduce legal risks as an employer? And my first immediate obvious answer to that is don't employ anybody. And that way you can almost, and I mentioned almost 100% guarantee you won't get an employment tribunal. And I say almost because even if you use contractors or subcontractors or casual workers or people that you have not imagined would be employees in your business or your organization, you could still find that by default, accidentally, they have become employees without anybody knowing anything about it. So that's always one to watch out for. So one of the legal risks you can minimize your risk there is by ensuring that from the very outset and during the whole life cycle of your staff, you are ensuring that you have the correct paperwork, the right documentation, the right employment contracts, the right policies and procedures, everything tickety-boo, all signed, all stored, all something you can get your hands on when you need to and refer to, and keep them updated regularly. So that's one of my top tips there. And do everything correctly. Take advice. Make sure that you are talking to people and following the procedure, not trying to take any shortcuts. So that's one there. Have you got a question there, Tracey? Want to answer the next one?
I do have a question here. This one is based around dismissing people, and this has come as a spillover from the webinar that we did a few weeks ago. And somebody wanted to know, can you dismiss an employee following a failed performance improvement plan? Well, of course, the short answer is yes, you can, because if you remember, capability is a fair reason for dismissal. However, you would need to follow a fair process, or we would always advise that you followed a fair process. And a capability process or procedure is similar in format to the disciplinary. So you would have a chat with that employee first of all, try and find out a little bit about why they're not meeting your expectations. So that would be the investigation. And if they had no mitigation, you'd obviously be looking out for things like, have they got some personal issues going on? Have they not been given the right training and tools to do their job? Are they in conflict with their manager or something like that, and they're just not getting on with the job? In which case you'd put something in place to help them. But if there was no mitigation at all and they just were not really reaching the expectations of that role, what you would probably do next would be to have a formal capability hearing with them, where they would most likely be issued with a first formal capability warning, and you'd then put that performance improvement plan in place for them. The performance improvement plan, otherwise known as a PIP, must be really, really specific. You need to tell them exactly what areas you are looking for improvement in, what tools and equipment they need to be able to do that. If they've got a mentor, somebody they can ask for a little bit of help. And most importantly, what does good look like? They have to know what the expectations are and how are they going to reach those expectations. You give them reasonable time to try and improve, okay? If there's no improvement after a reasonable time, you follow the process. Have another chat, investigation, maybe go to the next stage, capability hearing. They'd be issued with a final capability warning, given some more reasonable time, etc., and then you'd follow the next part again, and they would go through to a final meeting where you may be able to dismiss. So you have to be able to show that you followed a fair process. In my experience, it rarely gets to the final meeting because that person will understand that actually they can't do the job, they're in the wrong place, and they resign. So it's happily ever after. The next part of that little question that I had was somebody asked, can you terminate a contract of employment because the employee is a poor organisational fit? Not really, because poor organisational fit doesn't really fall into our bracket of the 5 fair reasons. Do you remember those? It was conduct, capability, redundancy, legal contravention, and some other substantial reason. I'm not sure poor organisational fit would fit into that at all. So I would say no, you have to pick one of those fair reasons. However, if you've got somebody with less than 2 years service, then they don't have employee rights. If they have no protected characteristics, haven't made any comments about health and safety issues or whistleblowing, and you feel quite clear that there's nothing that they could come back and say, you dismiss me because of a legal reason such as those, then you would, at the moment, before the rules change, be able to let that person go if you felt they were just being disruptive in a business or in a department. So don't do it without taking further advice. If you need to catch up with us later about anything like that, please feel free to do so. So less than 2 years service, you may be able to let somebody go because they're a poor organisational fit. But if they've got more than 2 years service or some protected characteristics, please don't do that. There we go.
Excellent. Thanks, Tracey. There's a good, interesting question come in from someone called, sorry, apologies if I don't pronounce the name correctly, Sophia. What happens if a tribunal is scheduled to take place after an organisation has been wound down? So this is not an unusual situation. What will tend to happen is if the tribunal has already been scheduled, then it will proceed. And what actually happens at the tribunal would depend on the circumstances, because it's unlikely that the respondent, as it would be in this case, is going to attend. But it may well be that an insolvency practitioner is involved, for example, and may want to send representatives or may be there in presence. But essentially, it will proceed. And then when the judgment is made, if it is a judgment in the claimant's favour, then, of course, the panel will have to assess the likelihood of them getting payment. And probably the most common situation is that the claim then sits with the insolvency practitioner along with other creditors. So it would be treated in that way. That's a very sort of simplistic answer to it, but anyway. What would you do? Sorry, there's another question. I can't see who this one's from because my box is a bit small. From Patty. What would you do if an employee contacts you via a solicitor saying they're going to take the charity to an employment tribunal when that employee hasn't engaged in a grievance procedure first? Did you want to take that one, Tracey?
Oh, sorry, I was just moving on to the next one. Can I leave that one with you and then catch up with the next one that's just come in? Thank you.
Absolutely right. So to take these one step at a time, really. So you've been contacted by an employee. Doesn't say here whether this is a current or an ex-employee. Let's assume it's an ex-employee. And the ex-employee is saying, you had a letter from the solicitor saying, we are intending to bring proceedings again. And the thing that the employee has to do before you can go to a tribunal is something called pre-claim conciliation, which is mandatory through ACAS. And that's when you have to, ACAS will contact the organisation to say there's a claimant here or an employee here saying they're going to bring a claim against you for whatever it is. And you are then invited, if you wish to do so, to enter into a conciliation process to assess whether you want to settle the claim, deal with it. But it's at that stage what we with our clients advise we can get much more information about what it is that they're claiming or what it is that they're saying they're going to bring a claim for. And then you can determine whether or not there's actually any merit to the claim, there's any risk. You can determine what the best way to handle it is, to manage the situation and so forth. So that is, I think, my advice. The question's disappeared off my screen. It's gone to another one. My advice in this case would be to get more information about what it is exactly the employee is claiming they are going to bring a claim for, saying they're going to bring a claim for. But if they, just touching on the grievance point, if they haven't raised a grievance, let's say, for example, the claim is for discrimination, or for unfair or for a constructive unfair dismissal, and it is the first time you were found out in any shape or form that they weren't happy, or there was a problem, or there was an issue or an incident or anything at all that's been a catalyst for their situation, then it does present a weaker case on their part because they haven't provided you with that opportunity to put it right. But it doesn't prevent them from bringing a claim. If you want, sorry, whoever it is, Patty, if you want more information or to discuss it more, I'll be happy to do so at a later date. Please just get in touch. Over to you, Tracey.
Thank you. Sorry I batted that one back. I'd just seen a question come in from Martin Kennedy. Good morning, Martin. Hope you're enjoying the session so far. You wanted to know, excuse me, how best to manage a situation involving a disruptive employee who's covered under the DDA. So he's disabled and he's disruptive. So just because somebody has a disability, it doesn't mean that they can get away with murder. What it does mean is that you have to handle the situation sensitively, and that you, again, have to follow a fair process. We're all about processes in this business. So my advice to you would be to, I don't know exactly what the situation is, obviously, but to have a meeting with that person, to have an investigation meeting with them, and to point out their shortfalls. You can do that, whether they have a disability or not. You can tell them that what you're not happy with, you can set the expectations for them. But what you must do is to ask what you can do to help them. So we've all heard about reasonable adjustments. So do they need any reasonable adjustments? Are they struggling in their job? Are they being disruptive because they feel overwhelmed or undervalued and they need some support? So that's the first thing to do. You would always have that chat with them, investigate, find out what's the matter, what can you do to help them. You can try and implement some reasonable adjustments. It doesn't mean that they can have whatever they want. It basically means that a reasonable adjustment is reasonable to both them and to you as the employer. Okay, so you try and make the situation work, and you still set those expectations, and you still keep catching up and checking in with that employee to see how they're getting on. If they don't improve, if their behaviour is still disruptive, even after you have put reasonable adjustments in place and you've listened to what they need, that doesn't stop you from going forward to a disciplinary or a capability meeting, as I explained a little bit earlier. So you would still need to follow that process, set the expectations, put reasonable adjustments in place. And what we're aiming for at the end of the day is if you had to dismiss that employee, they wouldn't be able to go away to a tribunal and say, they dismissed me because I'm disabled. It would need to be really, really clear and evidence that you had dismissed them because they were being disruptive, rude, late, taking long breaks, whatever that might look like. So again, most of these questions that we're going to try and answer for you this morning are going to be a little bit vague. So if you did want to come back to us and tell us the specific, I heard a dog bark then, and hear a specific, it's Lily, isn't it? And if you had a specific case that you wanted some more help with, then of course you're more than welcome to give us a call and we can help you with that. But hopefully that's answered your question a little bit. Follow the process, find out what they want, do what you can to help them, but it doesn't give them the right to stay in your business being disruptive because they have a disability. There we go.
Thanks, Tracey. Okay. Just very quickly to add on to that, I mean, that's absolutely perfectly correct. And we often get, don't we, clients who have employees where there is a mix of disruptive or underperformance or disruptive behaviour or something, and the employee is saying that part of the cause of their behaviour is either a mental health condition or some condition that they're suffering from. So the clear thing there, important thing there, is to be able to differentiate between what, if any, of the behaviours are attributable to their health or their medical condition that could potentially be considered a disability, and which isn't. So that would be handled through your investigation process. Sorry, anyway, that's excellent. A brilliant question from Beverly. If you ended up in an employment tribunal, what paperwork would you need, would be necessary, and what would the tribunal expect to see? And do you need legal representation, which is a great one, because I sit on employment tribunals as a member. We often have both parties represented by legal professionals, solicitors, barristers, and so forth. But quite often we don't, particularly in the claimants side. Respondents are almost, not invariably, but very, very often are represented legally. Claimants are more often are not than respondents. And it's not a requirement. You don't have to have a legal representative there to represent you and your case. What I would say is legal representatives will obviously have the experience, the technical knowledge and the expertise to present your case in the best possible way to the tribunal, because they understand how the system works, how the process works, what the tribunal panel are looking for. And often we get the claimants who are appearing in person, representing themselves, mistakenly believe that this is the opportunity they have to clear their name. And unfortunately, it isn't. Let's say, for example, someone's been dismissed for stealing or dismissed for unfair for some of the misconduct, and they want to sort of get their name cleared and prove that they didn't steal. Well, we're not there to decide that, unfortunately. We're there to decide whether the employer followed a fair and reasonable process in coming to the decision that they did. And it may mean that someone who could be fairly dismissed who actually isn't guilty of the crimes for which they were dismissed, oddly enough, but it can happen. So legal representatives can be very helpful in doing that. What paperwork do you need? Very briefly, you would need to have as much as you can that gives evidence for that you've behaved reasonably and fairly. So typical things: employment contract signed, policies and procedures, copy of your disciplinary procedure, and any evidence you've got that demonstrates and backs up what you are saying to the tribunal and you want them to believe. Right.
Okay.
Over to you.
Thank you very much. So, Liz, good morning, Liz. You've asked, what steps would you advise to make a fair ill health capability dismissal? Okay. So again, we have an ill health capability procedure that we must follow. Again, starting with the investigation. Again, seeing if there are any reasonable adjustments that you can implement to support that person. If the person has been off, or even if they haven't, to be fair, just backtrack there a little bit. If they're not at work or they're struggling at work, I would always advise that you had an impartial occupational health assessment and report for them. So you need a little bit of help, and you'd find either a GP, but quite often an impartial occupational health professional is a better plan. And you would obviously need to set out what that employee is required to do in their role, what you need them to be able to do, how they need to act, etc., etc. And the occupational health professional hopefully would be able to recommend reasonable adjustments, whether that meant removing some elements of their role or allowing them to work part-time or to take more breaks. And again, it very much depends on what the actual situation is. So if the occupational health report comes back suggesting reasonable adjustments and you implement those, but the employee is still unable to attend work or to complete their job satisfactorily, then you can take steps to move them out of the business. But again, to be doing this sensitively, giving them every opportunity to improve, giving them every opportunity to tell you what they need. If they're not able to come back to work or not able to fulfill most of their role, then you can either try redeployment. If there's a job that you can find that they can do, that's really a good plan if you can do that. Otherwise, you would have a meeting with them to tell them that you're going to consider ending their employment, giving them yet another opportunity to tell you, what you can do to help them. And if there's nothing at all you can do as an employer to help that person fulfill their role adequately, then of course you can remove them from the business and you can end their employment.
Okay. Thanks, Tracy.
On that, Dan? No?
Now moving on to Caroline.
Oh, okay, off we go.
These. Caroline has a team member that they have had to extend probation for 3 months, for another 3 months. But sadly, performance is still not up to scratch. So unfortunately, sadly, going to have to let her go, and it is sad. But it sounds like you've been trying your hardest, Caroline, to give her a chance to improve. Any advice? Yes, advice. Make sure that all your paperwork is in place. So meeting notes. You've got a copy of her employment contract. You've checked the employment contract to make sure that you're following your own procedures in respect to the probation period and dismissal procedures. And essentially, the evidence that we would look for at a tribunal really is what is the criteria that she did not meet, and was she given every fair opportunity to do so, and was it reasonable, and so forth. So provided you've got an evidence of at least one meeting where you've sat down and you've explained to Caroline that things are not going well, it sounds like you probably did that at the first probation review, that things are not going as well as they might, and these are the areas where we need to see improvement, and this is what we need to see from you, and you give us some deadlines, you give us support, ask whether there's any help she needs, etc. And then if she doesn't meet it, unfortunately, you can just say we failed probation in accordance with your policies and procedures. Was one of the things I was going to say? Yes, normally you see someone with less than 2 years service, although that's going to disappear, as Tracey alluded to earlier. In the next over the next year, that's going to be changed, so they won't need any minimum length of service to bring a claim. But at the moment, they can't bring a claim for ordinary unfair dismissal with less than 2 years service. However, you can bring discrimination claim, for example. And you can bring a health and safety whistleblowing claim without 2 years service and so on. So that's why you need your ducks in a row, so to speak, in order to make sure that you can, if challenged, demonstrate quite clearly that the true reason or the principal reason for dismissal was conduct or capability, in this case, one of the two.
Okay. Thank you, Dan.
Back to your case, I think, Tracey.
Yeah, I think it is. Thank you very much. Sarah's just asked, following Liz's question, we were just talking about ill health capability. What if they don't want to follow the occupational health report? Well, that's up to them, basically. You should always make them aware that the occupational health report is for their benefit, because you are not medical professionals and you need to know from a medical professional how you can support them, okay? You don't know what to do. You don't know how to help them. So if they absolutely refuse to have an occupational health assessment, all you can do is continue with that situation without the professional medical advice. And that's going to be a detriment to them. So I think that's probably all I can say to that. You don't have to force it, but it's up to them, isn't it?
That's right. Yeah, okay. From a tribunal's point of view, as a tribunal member, if you can see that you've done everything you can to get all the medical information, and I mean, an employee doesn't even have to agree to let you see a doctor's report, but as Tracey said, it's up to them. Well, I think we're going to move on to another poll.
Okay, I was just going to squeeze in a quick one before the poll, but there you go. What shall I do? Quick question, Amy, or poll? Poll. We're going for the poll. Amy's in charge. Come on, then.
Thanks so much, Shannon, Tracey. This is great. Just another poll we wanted to get your insights on as an audience. Are there any aspects of employment tribunals that worry you the most? Be a great time for you to choose one of these options. So again, Dan and Tracey can kind of advise you. Feel free to click on this. And as we're waiting for you to complete the poll, Tracey, which question did you want to answer next there?
Well, after the poll, I was going to go to Trisha's question, actually, about notice periods. That's okay? Absolutely, go for it. Oh, okay, so here we go then. While you're all thinking about the poll, I've just picked up a little quick question from Trisha. Morning, Trisha. She wants to know the maximum length of notice period that an employer can require an employee to give when resigning. Well, obviously, it's not obvious at all. Obviously, you wouldn't have asked the question, so apologies for that. You would look back at their contract of employment. What notice period have you requested they give when resigning? You don't have to adhere to it. So if somebody has resigned and they're going off to get a new job and they want to go in 2 weeks rather than the 4 weeks you've stated in their contract, and you're actually quite happy that they're going, which is often the case, then you can mutually agree to let them go in 2 weeks' time, for example, after they've done their handover. I would advise that you put this in writing in their acknowledgement of resignation letter. So make sure that you've crossed all your T's and dotted all your I's and written, we mutually agreed to you leaving on blah, blah date. And of course, from the other side of the notice periods, as an employer, you've got your statutory notice periods that you must adhere to. So basically, if somebody's not been employed for a month, you don't need to give notice. If they've been there a month but less than 2 years, then you should be giving them 1 week's notice. And then 1 week's notice for every completed year of employment between 2 and 12 years. So really, if you've got somebody who's been with you for 12 years or more than 12 years and they're now leaving and you need them to leave, redundancy or whatever that might look like, then you are obliged to pay them 12 weeks pay, 12 weeks notice. So hopefully, Tricia, that's answered your question.
Great. Thank you so much, Tracy. We'll just pop to see what the results were of this latest poll.
Yeah.
Cost. I thought it would be cost.
Yeah, well, it's a neck and neck tie for first and second there. Damage your reputational brand, which is true. We do have clients, don't we, Tracy, who are very worried about actually taking a case, a claim that they receive as far as tribunal because of the risk to their business if they're seen to lose a tribunal, particularly people who work in public sector or than charities, supportive organisations that work with local councils where you have to tender for contracts with the councils, things like that. It's a big no-no to lose a tribunal claim in order to go to win future contracts. So we get that, understand that entirely, and that's very damaging. And cost, obviously, is a big one. Yeah.
Right. I have got a question from the last webinar that we did, if you'd like me just to kick off with that one again, if that's all right. Yeah. So somebody said, can we elaborate more on the issue of the right to work from home for some employees who live far from the office and no right to work from home for others who live closer? Will it be discrimination? Maybe. So I think what I would always do is remember, when the person who lives, should we say, 30 miles from the office took the job, they knew that they would have to be driving 30 miles to work. Okay. So is it fair to say they can work from home, where somebody who works 3 miles from the office can't? Not really. I think if your organisation supports a hybrid working plan, then from a staff morale standpoint, it's better to offer it to everyone and see who wants to work from home, who doesn't. So being fair and consistent across your workforce is by far the best way to go with this. However, don't forget, the person who works or lives rather 30 miles from home is entitled to have a flexible working request flexible working. I couldn't think of the word there. And you can agree to that. And flexible working, of course, is on a first come, first served basis. So you could agree to that person working from home, and then you could say no more people are able to do that. So you could get away with it that way. But certainly from a moral standpoint, if you can have a hybrid working pattern in your business, then open it up to everybody and see if you can make a plan so that everybody's happy. You shouldn't really penalise a person who lives 3 miles away just because the person who lives 30 miles away wants to work from home. Okay, so that's the answer to that one.
Okay, great. Thanks, Tracy. We got a question from Jasmine. What can we do if an employee has hacked into his email account after leaving to obtain evidence for a pending constructive dismissal tribunal? Well, that's a great question. Now, raises a whole range of different things. One to consider is to speak to your lawyers or legal team about whether there has been potentially a breach of the Computer Misuse Act. which could be pursued. Second thing, obviously, is to make sure, I say obviously, but to lock down and ensure that no other further breaches might be able to occur. Understand whether there's been any Data Protection Act breaches also, if any personal information may have been obtained that does not even pertain to the individual himself. In respect of the tribunal itself, then whether or not evidence is admissible that has been obtained unlawfully or illegally would be something that your legal teams or representatives could make an application for in respect of defending the claim at tribunal, and the panel would then have to consider and weigh up the pros and cons, if you want to put it that way, about how the evidence was obtained versus whether it prejudices anybody's case, and look to see whether or not it's going to be admissible as evidence. So that's a very brief summary of answering that question. But if there's anything further you want to know specifically, please do let me know afterwards.
Thank
Tracey.
you, Dan. Beverly Cook, hello. You've got an 82-year-old engineer, wow, employed, and he's been with you for 14 years. Work is still proficient, great, still doing a good job, but he's quite slow, okay? And he currently works 3 days a week. You'd quite like him to go down to 2 days per week, but he's happy to continue working in the workshop for 3 days. Can you insist he reduces his days? No, not really. It's his terms and conditions, and any terms and conditions can only be changed with mutual agreement. So he's doing a great job, isn't he? At 82, still working away there and not making too many mistakes by the sound of it. So that's all good. If you were adamant that you wanted him to not be there any longer or work less days, the only thing you can do that is to follow a fair process and look at his capability and his performance. So hopefully you wouldn't want to do that. There isn't really much we can do to insist that he reduces his days in the workshop. He's currently doing 3. I think we have to sort of work with our employees, don't we? And if he's still doing a good job for you, still doing 3 days of adequate work, then you've got a lot of people possibly who are younger in the world who don't do such great work. So I'd be quite happy that he's been with you and he's committed to the company and he's doing his best after 14 years. So sorry, but no, you can't insist he reduces to 2 days unless he wants to.
Great, thanks, Tracey. Trying to squeeze a few in here before the end of almost at the end of the program. It's like we're doing a radio style in here, which is good. Hannah says or asks, should every new employee sign the handbook / policies when they start? It is currently a company document stored on Breathe, accessible in the office. Could an employee say, I didn't sign the handbook policy later on if something went to tribunal? And this is something that happens often, is that people either claim that they didn't see a policy, didn't see a document, didn't know it, never read it, never had it. Rule of thumb is wherever it is practically possible to do so, get a signature on a piece of paper, because there is then absolutely no argument, no question, and you are 100% rock solid, secure, locked in that you have clear evidence that the person received, signed and agreed to the terms and conditions or the policy or whatever it was that's dispute in the tribunal. Having said that, if it is somewhere where the employee can clearly get access to it, it is brought to their attention, and this is something that should be done really during induction, during someone's induction and training stage, is that they should be evidence that they have been shown how to find the employment manual, the staff handbook, where it is, etc., and also evidence that it has been issued. The fact that someone doesn't sign it and then later claims that they didn't agree to certain elements of the policies really doesn't hold much water, because if an employee has their employment contract's been issued, their policy's been issued, and they are complying with everything under those terms of that, they're working for you, they're attending work, they are receiving payment from you and accepting that payment, they do what we something technically called affirm the contract. So by affirming the contract, it means that really they are accepting the terms under which they've been employed. Whether or not they have their handwritten signature at the bottom, it really doesn't matter, but it's always best to have it there.
Thank you, Dan. Coming toward the end, so I'm going to dive in with a quick one from Alexander. You've got an employee who is very often late or sick, and she's been raising suspicions of staff. What advice have you got for us? So, have a chat. First of all, we need to find out, we call it the investigation meeting. Why are they late? Have they got a good reason? As the bus timetable change, if they've got to get kiddies to school, what does that actually look like? And if they're late because they've got a really good reason, you may consider adjusting their start time. It might work for you, it might not, I'm not sure. But if they, have got a later bus to catch, perhaps allow them to start at 9:15 rather than 9 o'clock, for example. And as for being off sick, then follow your sickness absence procedure. So what we would suggest is every time somebody is off sick, you have a return to work meeting with them on the day they come back. This lets them know that they've been missed, that you're aware of their absences. You would then ask, why have they been off? What's been the matter? Have they contacted a doctor? And most importantly, you'd point out to them, you've now been off 3 times in the last 6 months, and then you're able to say to them, if you have any more absences, we will be following your formal managing absence procedure. And that would lead down the path of managing somebody out because of their sickness absence. It could, of course, be that there's an underlying health condition that they have not been telling you about, in which case you'd need to offer them some more support. It could be that we go down the route of the occupational health report that we just spoke about. But the first thing is to investigate and to find out why. So don't always go diving in and trying to catch people out. Sometimes it's more a case of sitting down and talking to them and finding out if they've got a good reason for their lateness or a good reason for their illness. And first of all, can you help them? If things go a little bit wrong, we don't want it to look like you've been on a witch hunt to try and get them out. We need it to look like you've been supporting them and trying to help them to do the best job that they possibly can. And again, as we're coming to the end, if you want to talk about that a little bit later, please by all means give us a shout.
Okay, I think Amy, is that the last we got? There is another one there, but what do you want to do, Amy? Have we got time to answer it or not?
Yeah, please, if you could go ahead and answer the question from Adam, that'd be super.
Great, thanks. Adam, you're asking about an employee who's been absent for 61 days of their 83 days of employment with you, all for various reasons, but the underlying condition is long COVID. Are you at risk if you end their employment? So the key thing here is whether or not long COVID or the underlying condition that actually follows off what Tracey was just saying could be considered a disability and therefore protected under the Equality Act, which really then is a question about how you handle it. It doesn't mean you can't dismiss somebody, but it's about whether there are any reasonable adjustments that could be made in order to enable them to continue to work. The key thing about long COVID is not automatically a disability, but it could be a disability depending on the impact on the individual. So the test is whether there is a mental or physical impairment which has a substantial, adverse and long-term impact on the employee's ability to carry out everyday normal duty, activities. And if the impact on that individual of long COVID